Aligarh Muslim University is a minority educational institution with significant constitutional provisions to manage its affairs or not. This is a debate which has been ongoing in our country since the last many decades. And finally, Honorable Supreme Court of India has given its judgment, has given its verdict.
To overturn a key 1967 judgment of the Aligarh Muslim University, which removed the minority status but left it to a regular but yet unconstituted three-judge bench to decide if the institution should be granted this again.
Although still it is not clear or still it is not certain that AMU is a minority institution. The reason is that Honorable Supreme Court of India has given a test. Now, Franklin D. Roosevelt, the 32nd President of US, has famously remarked that no democracy in the world can survive for long if they do not acknowledge the right of minorities as essential to its own existence. And in the same line, a 7-judge bench of Supreme Court of India in a 4-3 majority verdict has given a holistic and realistic test to determine the minority character of educational institution in our country. And it has left the factual determination of AMU as a minority institution or not with a smaller bench. However, this ruling has essentially cleared the decks for AMU to be a minority institution, to get a minority institution status. Also, alongside this, Honorable Supreme Court of India has overruled its 1967 judgment given under the S. Aziz Basha versus Union of India case, which held that an institution incorporated by a statute in our country cannot claim to be a minority institution or cannot claim the status in our country. Now, what this judgment is all about, we'll be trying to decode in this particular session. Hello, my name is Preetpal Singh and you're watching Perspective. Now, in a narrow 4-3 majority verdict, Honorable Supreme Court of India on November 8, 2024 has overturned its 1967 S. Aziz Basha versus Union of India judgment, and it has previously served as the basis of denying Aligarh Muslim University the minority institution status. Now, this majority verdict was penned by former Chief Justice of India D.Y. Chandrachud and also endorsed by Justice J.B. Pardiwala, Justice Sanjeev Khanna and Justice Manoj Mishra. Although Justice Suryakant, Dipankar Datta and Justice S.C. Sharma, they dissented on separate opinions. Now, the issue of whether Aligarh Muslim University is a minority institution or not under Article 30 of our Constitution is now left to be decided by a regular bench based on its view of the majority. Now, let's first look at Article 30 of our Constitution. Now, Article 30, Section 1 of our Constitution guarantees religious and linguistic minorities the fundamental right to establish and manage educational institutions of their own choice. And also Article 30, Section 2 of our Constitution, it further mandates that the state must ensure equality of treatment in granting aid to educational institutions regardless of their minority status. Notably, such institutions, they enjoy greater autonomy than the others. And under Article 15, Section 5, they are exempt from providing reservations to the scheduled caste and scheduled tribes. Also, they may reserve up to 50% of seats for the students from their own community as well. Also, in a landmark TMA Pi Foundation case of 2002, Supreme Court of India clarified and held that the minority status should be determined based on the demographic composition of the concerned state rather than the national population. Now, first let us try to understand the chronology and the background of the whole case, and then we'll be moving towards the judgment in detail. See, it all started in the year 1875 when a Muslim researcher, a reformer and a educationalist, Sir Syed Ahmad Khan, established a Mohammedan Anglo-Oriental College, MAO College in Aligarh to offer modern British education rooted in Islamic values to Muslims. Now, in 1920, many years after this, the Aligarh Muslim University Act was passed, and it incorporated MAO College and Muslim University Association to form Aligarh Muslim University. And under section 23 of this act, only Muslims were permitted to be the members of this university's governing body, known as the court. And many years after this, in 1951, the mandate of the Muslim-only representation of the court was abolished. Now, there was a subsequent amendment which happened in the year 1965. So in 1965, the court's powers were redistributed amongst other administrative bodies, and it also allowed the President of India to nominate members in it. And eventually in 1967, the famous Aziz Basha versus Union of India judgment came by the Honorable Supreme Court of India. And the Supreme Court of India, they upheld the earlier done amendments. And they gave a reasoning that AMU was neither established or administered by a Muslim minority, since it has been established through central legislation, that is through a statute. That is why it cannot have a minority status. And this decision led to widespread protests amongst various organizations and various groups in our country, which eventually led to government passing an act in 1981, thereby amending the AMU Act, and it officially recognized the university's minority status in the country. Now, one more very important thing happened in the year 2005. In the year 2005, the university introduced a proposal or a policy of reserving 50% of the seats in the postgraduate medical course for Muslim students only. And this was subsequently challenged in the then Allahabad High Court. And Allahabad High Court struck this proposal or struck this policy of AMU down and said that AMU as a university does not qualify as a minority institution as per Aziz Basha 1967 ruling of the Supreme Court of India. And in the year 2006, a two-judges bench of Supreme Court, they stayed this reservation policy of AMU and they referred this case to a larger bench. And eventually in the year 2019, a three-judge bench led by the former Chief Justice of India Ranjan Gogoi referred this case to a seven-judge bench. And this matter all stayed in limbo till October of last year. The former Chief Justice of India, D.Y. Chandrachud, constituted a seven-judge constitutional bench to hear it. And now, in 2024, in 4-3 majority verdict, the Supreme Court of India has overruled the 1967 Aziz Basha versus Union of India judgment. Now let us see what does the former Chief Justice of India D.Y. Chandrachud has to say about this judgment. Now Chief Justice D.Y. Chandrachud, in an expansive interpretation of Article 30, has said that the educational institutions which were established prior to implementation of our constitution or adoption of our constitution are equally entitled to the protections granted under the Article 30 Section 1. He also clarified that statutory enactments conferring legal recognition or status upon such institution does not compromise the minority character of these institutions, providing their fundamental nature or providing their fundamental aim or purpose was predominantly aiming to benefit the minority community. If that is the case, then those institutions which were formed, they do not stop being of the minority character just because they were passed by a statute. And also the majority verdict further emphasized on one more important point and said that the institution does not forfeit its minority character just because the administration is no longer amongst that community. And the judges reasoned that the minority community or the founders of the minority community, they might appoint individuals or they might appoint experts from outside of the community as well. They can also be at the helm of the administrative affairs in that university or educational institution, particularly in an institution which focuses on secular education. And also this might be a case in professional colleges which are providing specialized courses in either law, specialized courses in medicine, architecture, where the founders, they might not possess the knowledge or they might not possess the experience or insight which are necessary for the character or which are necessary for the management or administration of that institution. In that case, they might hire or they might appoint people from outside of that community as well. in order to ensure that there is secular education and there is technical education. In that case, the minority educational institution status should not be a cause of worry. Now let us very briefly focus on the test laid by the Honorable Supreme Court of India. Now, to determine that whether an educational institution is of minority character or not, the Supreme Court of India said we have to pierce the veil and look into that how this educational institution was established. And to see this, Supreme Court of India laid down a test, laid down a certain criteria or indica that must be considered as a part of this twofold test. Now let's talk about establishment first. Now the first part of this test, or first aspect of this test, it deals with the genesis or origin of this minority institution, the purpose of establishment, and also how the idea of this institution was first implemented. And courts must also trace the origin of the idea for establishment of such an institution. On the origin of the idea also, they must focus first from where the idea came for establishment of this kind of institution. That is one thing which they need to focus upon. And the main reason to do so is to determine that who was the brain behind establishment of this particular institution. And Supreme Court of India also said that for proof, a variety of sources can be referred through. It can either be letters, it can be either correspondence of the officials of the other community members or government officials as well. And the link must point towards one member or the group which is a part of that community. And Supreme Court of India also said that the purpose of establishment of such educational institution must be to serve the minority community and must be predominantly for benefiting the minority community, even if it is not the sole purpose. Here the court also suggested that correspondence or even the speeches from the time when this education institution was being set up, they can also be referred to in order to understand the purpose of establishment and also to recognize the educational difficulties which were faced by that minority community which is in question. Also, the Supreme Court of India said that the next step is the implementation of the institutional idea. First is that who came up with the idea and from where the genesis of the idea came, and second is the implementation. In this, a lot of peculiar questions are involved. First question is that who gave the fund for establishment of this institution? How was the land obtained or how was the land bought? And the last is who obtained the necessary permissions and who did the construction of the infrastructure for that institution. And after considering all these factors, then eventually a decision needs to be taken or should be taken that a particular educational institution is of a minority character, minority status or not. Now there were several dissenting opinions which were also given. One such was given by Justice Datta, who said that if AMU is given a minority status, after 100 years, it might lead to a historic revisionism, and he also critiqued that there was a lack of constructive discussion amongst the judges for this particular judgment. So he also pointed out towards the lack of proper discussion and deliberation amongst the judges as well. But eventually, this judgment was given by a 4-3 majority. That means 4 judges were towards this decision and 3 judges, they had a dissented opinion. Now the real question is, what happens next? Now Supreme Court of India under this judgment of 2024 has given or laid down a test. Now a regular bench assigned by the Chief Justice of India Shri Sanjeev Khanna will now re-evaluate the Aligarh Muslim University's minority character. And it will be based on the recent Supreme Court of India's judgment. And it will be without any considerations of the Aziz Pasha judgment. And meanwhile, the stay on university's 2005 policy will remain till the time it gets a minority status and till the final determination is over. Now this reassessment is going to have far-reaching impacts on Aligarh Muslim University's autonomy, its authority to reserve seats for the Muslim candidates, and a broader discourse on the minority rights in India. Now, what are your views of this judgment? Please let me know in the comment section and let us have a healthy debate. I hope you gained a new perspective and this judgment you are able to understand now. All the very best and have a beautiful day.